All right. Um, Now we are going to move on to the beginning of the Stoller case, and we'll sort of go from there. They're basically what had happened in this case was hybrid decision, probable cause, no probable cause, not that great. We go forward on that. Have the no probable cause thing. While that's going on, we have the Alice DeLau hearing on the Novak case and revelation that Alice DeLau knew that Amy Petchacek was a witness, was an actor in that case, and did nothing and said nothing, and then put it all on us. So at that time, we raised that issue and sent an email to Secretary Petchacek saying that she needed to notify all DOC complainants of her position, and that we instructed John C. Gelhard that he needed to divulge his conflict there. He made no response. Neither did Petchacek. That was June maybe of 2023. October, same thing. Nothing happens. Nothing. Okay? They, at some point in about December at the close of discovery, we decided that we want to subpoena Carr and Petchacek. Why we waited until the last minute? Possibly strategy. I don't know. So what happened was the Department of Justice from the Wisconsin Department of Justice came in and represented both Carr and Petchacek. They got their own attorney who is Samir, Jaber Samir. And he entered an appearance on behalf of Petchacek and Carr. So keep in mind that the Department of Justice is representing the judge's boss to the judge. Okay? No question about it. So then that attorney for Amy Petchacek comes in and files a motion saying that I shouldn't be able to depose Amy Petchacek. And that's where we're at. For the fifth time. For goodness sakes. Okay. Yeah, we'll improve that a little bit. Boom. All right. Who do we got here? John Gelhard, that's the judge. Yours truly. Michelle Zacard, she is the attorney for the Department of Corrections. Jaber Samir S., he is an attorney for the Department of Justice, representing Petchacek and Carr. And Wackenhauser, who is the Amy Petchacek's personal attorney. All right. Good afternoon. Please see attached motions for protective order for Amy Petchacek. This document was also now, so this right here is the Department of Corrections. And as far as I know, the Department of Corrections filed on behalf of, just filed a motion on behalf of Amy Petchacek, which again, she was represented by Department of Justice, who I think then also filed a motion, but the Department of Corrections filed a motion saying that we shouldn't be able to depose his boss. Okay. Now, nowhere in here do you see, there's a motion, but nowhere in the motion is there a statement saying that we conferred because we did not confer. Dear parties, I am in receipt of the respondent's motion. I have not received anything from, so they filed this at 3:35 on Friday, December 8th, is when they supposedly sent that. Oh, they emailed it and then faxed it out. Okay. And this is when? Monday at 5 o'clock. I am in receipt of the respondent's motion. I have not received anything from the complainant. Given the approaching discovery deadline, I will give the complainant until tomorrow at 4:30 to file a responsive brief. After that time, I will move forward with the decision on the motion. Yeah, that's less than 48 hours to respond, which is, and at that time, seeing as he did not have jurisdiction over it, it's completely preposterous. Here's what we respond. Judge Gelhard, there is no reason to think that you would have received anything from the complainant. We are very concerned about the short response time will result in prejudice. First, we object to the hearing of these discovery motions without the required conference or certification of conference. Period. The end. We can respond on that issue by tomorrow. As to the merits of the two motions, I cannot possibly respond by the deadline you set, which is less than 24 hours. I have no idea if I can reach my client or get the necessary affidavits. Furthermore, I am otherwise engaged until Wednesday afternoon. We request a hearing on this matter. There is no reason why the discovery deadline should be inflexible at the prejudice of the complainant, where the state failed to confer on the testimony from the complainant's deposition. Finally, we do not have the recording of the deposition ready by tomorrow. The record is incomplete and will not be complete tomorrow. Rush will only cause prejudice and cloud the record. We need time. Ben Hitchcock Cross. Okay. See what he says. The respondent filed this motion on December 8th. You had until December 9th, December 10th, and December 11th, which is totally untrue, to consider the motion that was filed. This is the weekend. You should have spent your weekend dealing with their motion that they filed on 3:30 on Friday. That's what he's saying. You failed to file anything in that time. You can see possibly why the issue of Hanukkah, which may be this week of December 11th, Hanukkah is more than 2 weeks, more than 1 week, to consider that motion was filed, may arise here. You failed to file anything in that time because there was no deadline or reason to file anything because they had not conferred. He still doesn't distress that issue, does he? No, he doesn't. With the discovery deadline of December 18th of 2023, I felt that the deadline of December 12th to respond would give the party sufficient time to schedule any remaining depositions. Okay. Tough toodles. There's still a rule. The matter was certified to hearing more than 2 years ago. Discovery may begin as soon as the case is certified to hearing. You had almost 27 months to schedule and conduct depositions of the individuals that you felt were needed for the hearing. Nevertheless, you were apparently trying to schedule depositions 10 days before the discovery deadline. Sure. I am willing to allow complainant's response no later than Thursday, December 14th at 4:30 p.m. Oh, here we go. ALJ Gale and his counsel representing Secretary Petchacek, I want to inform you that Attorney Cross has belatedly served his subpoenas for her deposition for Friday, December 15th by process server to GEF, I don't know what that means, 1 this afternoon. I have attached the subpoena. That could be some state lingo. I want to first state that I sent a notice of appearance on behalf of Secretary Petchacek on Friday afternoon, and I sent those notices to Attorney Cross by email, fax, and USPS. And the notice clearly states that all future documents, discovery, and correspondence be served on me. That doesn't mean service of process, dude. As her counsel, in addition, I have been copied on several emails between the parties since I filed my notice of appearance and my notice joining the DOC's motion for protective order. That Attorney Crow still failed to send subpoenas directly to me is troubling and okay, dude, a potentially violation of Supreme Court Rules 24-2. Okay. Okay. Our objection to subpoenas, as outlined in our notice, joining DOC's motion for protective order, is only buttressed by Attorney Cross' unreasonable expectation that agency secretaries sit for a needless deposition with less than 2 days. Okay. Secretary Petchacek is not available to sit for a deposition at that date and time. This is when, taken in consideration with the belated nature of seeking the depositions only days before the discovery cutoff and the troubling concerns raised by DOC's counsel regarding Attorney Cross's refusal to confer, only emphasizes the basis for granting DOC's motion. Oh. We can get into that, but I think they said they called me and I didn't call them back. That's kind of a materially false statement, dude. But okay. Finally, Secretary Petchacek reiterates on the other basis for quashing the deposition as outlined in the DOC's motion for protective order. Namely, that the complainant will be unable to establish why this immunity conferred to high-ranking officials under state and federal law should not apply in this circumstance. I understand that Attorney Cross has been given until tomorrow to file a response in this motion. In the event that the DOC's motion, she is ordered to sit for a deposition date despite the discovery cutoff, Secretary Petchacek would suggest that the discovery cutoff be extended for the sole reason to find a time to schedule her deposition at a time that is mutually convenient. I appreciate your consideration. Now, do you see any mention in here of Secretary Petricek's holiday plans? Just wondering. Do ya? I don't. Okay, let's keep going. Boom. Dear parties, please see the order relating to the events described below. Oh, let's look at that. Order to quash subpoena. Okay. What happens if we go here? Okay. Impartially, ALJ shall perform his duties impartially, competent, and diligently. The ALJ shall not initiate, permit, or consider ex parte communications or considering of communications made to the judge outside the presence of the parties concerning a pending or impending proceeding except where circumstances require ex parte communications. Okay. How about an opportunity to be heard? Do we see that? Oh, a DWD-ALJ shall accord to all persons who are parties to a proceeding or their representatives full right to be heard according to the law. Nothing like getting a notice out there that you don't have to be somewhere. Okay. Well, let's go back and look here. Procedural history. On Friday, December 8th, attorney Michelle Zacard, counsel for the Department of Corrections, filed a motion for a protective order, arguing that for reasons stated in the motion, Amy Petricek, acting secretary of the Department of Workforce Development, State of Wisconsin, should not be compelled to sit for a deposition in the instant case. Assistant Attorney General Samir Jaber, representing Ms. Petricek, my boss, joined in the motion for a protective order. That in itself is kind of an astonishing statement. Somebody who didn't represent her filed the motion and then they joined on later. But okay. I mean, I don't know why that necessarily has to be improper. But okay. On Monday, December 11th, at the close of business, administrative law judge ALJ John Gelhardt, having received no response from the complainant to the motion for a protective order, set a deadline for filing a response to the motion for a protective order for Tuesday, December 12th at 4:30. So far, so good. ALJ cited to the fact that the deadline for discovery was December 18th, and therefore time was of the essence in making a decision on the motion. Okay. Later on December 11th, counsel for the complainant, attorney Ben Hitchcock Cross, wrote to ALJ Gelhardt saying that he was otherwise engaged until Wednesday afternoon and worried about the short return. False. That's false. I'm sorry, but we can't let that stand here. We just read it, but it's also true that they didn't confer, and that we didn't have all the material sufficient to respond. That's not a fair. That is not a fair summation of what I wrote there. On Tuesday, keep in mind that without a clear objection on that, the review commission would just have this statement here, which is false. I mean, it's false. It's not what I said. On Tuesday, December 12th at 8:09, ALJ Gelhardt extended the time for complainant to respond until Thursday, December 14th. Okay. Now, again, I was otherwise occupied. So I had less than 20, and I think I was able to do this in about 3 hours, which was, again, outrageous. On Wednesday, December 13th at 4:40 p.m., attorney Jaber sent an email to ALJ Gelhardt informing him that the complainant had served a subpoena on Amy Petricek, ordering her to sit for a deposition on Friday 15th. A copy of the subpoena was attached. Attorney Jaber cited several reasons for objecting to the subpoena, as cited, and said it was an invalid subpoena. Do you see where Attorney Hitchcock Cross gets to respond on any of those issues? You don't see that there, do you? Under DWD 218.14.3, the scope of discovery, the methods of discovery, and the use of discovery at a hearing shall be the same as set forth in Chapter 804 Stats. Under the rule, the administrative law judge may compel discovery, issue protective orders, and impose sanctions in the manner provided under 804 Stats. And just so we know, because this, in my understanding, this judge has hidden the ball before. Let's just read the entire old statute here. I'll pull that up, and then we can be clear. Gotta love these first-hand sources. 218.14. Let's go down to 3. Scope and method. The scope of discovery, the method of discovery, and the use shall be the same. 4. Failure to comply with the discovery request, duty to consult with opposing party. The administrative law judge may compel discovery, issue protective orders, and impose sanctions in the matter provided under 804 Stats. Oh, let's see what else there is. All motions to compel discovery or motions for protective orders shall be accompanied by a statement in writing by the party making the motion that, after consultation in person or by telephone with the opposing party and sincere attempts to resolve their differences, the parties are unable to reach agreement. The statement shall set the date and place of such consultation and the names of all parties participating in the consultation. Okay. It seems like he left that out. The department or a party's attorney of record may issue a subpoena to compel the attendance of witnesses. A subpoena issued by an attorney shall be substantially the same. Upon motion or made promptly in the event or before the time specified in the subpoena or for compliance therewith, the court may quash or modify the subpoena if it is unreasonable or oppressive. Now, I'm just going to ask you there, given everything that we've read, I don't dispute that 805.073 says that. He does have the power to quash the subpoena. Okay? No question about it. Protective order. No question about it. But let's go back. The administrative issue protective orders and impose sanctions. All motions to compel discovery or motions for a protective order, which is what we have, shall be accompanied by a statement in writing by the party making that motion that after consultation in person or by telephone with the opposing party and sincere attempts to resolve the differences, the parties are unable to reach agreement. All right, well, that's where we're at. I mean, that's kind of the question is, can you read DWD 218.14.3 without reading DWD 14.4? That's the question. The respondent and Ms. Petricek, and just to go before that, even if, because there's no statement or on confer, but also, can you hear a motion without giving the other side the opportunity to respond? Let's find out. Subpoenas and motions, it's right there. Oh, disqualifications under there too. DWD 218.15.2, motions. Motions made during a hearing, so that's not this one. All other motions shall be in writing and shall state briefly the relief requested and the grounds upon which the moving party is entitled. All written motions shall be filed with the administrative law judge assigned to the case. Any briefs or other papers in support of a motion, including affidavits and documentary evidence, shall be filed with the motion. How about this one? Any party opposing the motion may file a written response. all written motions shall be decided without further argument unless requested by the administrative law judge. Okay? That word may there makes it discretionary to me to file a response. Any party may. If I want to, I can. I don't have to. That he cannot determine that we haven't done that without giving us the opportunity to respond. It's called notice and opportunity. That hadn't happened. Okay. The respondent and Ms. Petracek have set forth reasons why she should not be deposed in this case. The complainant has been given an opportunity to address the reasons. False. So that is a false statement by an ALJ, and he signed an attorney who assigned his name to that statement. The complainant has been given an opportunity to address those reasons. As such, serving a subpoena for deposition prior to the decision on a motion for a protective order is per se unreasonable and impressive, as there has not been a determination as to whether this individual should be subject to a subject of a deposition in the first place. Okay. Okay, so I guess let me reread that there. It's true that he had been given an opportunity to respond, but the complainant has not yet. The deadline for the complainant to respond moved several times, has not yet occurred. That's fair. That would be a fair statement. But that the complainant has been given an opportunity to address those reasons is inaccurate. Even to say 24 hours notice to put that is not notice an opportunity to respond by any stretch of the imagination. Oh, in addition, it appears that the service was defective. Okay. The subpoena served on the 5th need not appear for the 15th. So on the 14th here, he signed this affidavit this order without giving me a chance to respond. By the way, motion for a protective order and motion to quash the subpoena are identical. A motion to quash is simply another form of a motion for a protective order. All right, well, there you have it. That is sort of the opening act here of what I was doing during this week of Hanukkah, which is madly trying to respond to this brief. And let's just be clear. The fact that it took 3 or whatever hours to respond just to the brief does not account for all the time, aggravation, and frustration it did with trying to rearrange to be able to respond with less than 24 hours to go. Because the original deadline, remember, is at 5 o'clock for the next day at 4:30. And we never had any 24 hours. And that trying to rearrange childcare, trying to rearrange activities and so forth. I mean, that's the question there. Do I cancel a holiday dinner to get this thing done on this ridiculous or preposterous deadline? And then we're going to come to find out what the real reason why this thing had to be rushed was. Because it certainly wasn't the discovery deadline. I believe that was a disingenuous statement there. But we'll find out. Okay? All right. Thanks for sticking with us. We will keep you informed. That is for sure. We got a lot more to go, people.